And the law at the time, for one thing, trademark infringement and dilution law was applied to those situations really pretty successfully. I mean, the trademark holders really didn't need much else. But the law continued to evolve in the late 1990s, and we ended up with the Anti-Cybersquatting Consumer Protection Act in the States, and also with the Uniform Domain Name Dispute Resolution Policy at the international level administered through ICANN. And all of that is really very, very much focused on protecting trademark holders against people who are effectively trying to extort money from registering domain names corresponding with their marks. And whether you think that conduct should be prohibited or not, and views vary on that, that's the way the law developed in the 1990s. But that kind of conduct was fairly easy to deal with, assuming that enough people thought that was illegal, wrong, and should be regulated. It was fairly easily regulated. And trademark holders now are aware that they need to register domain names that correspond with their trademarks, and even if they lose out on a particular domain name, there's enough law there that's based on trademarks to protect them. But what's happened in the intervening years is a whole lot of other kinds of disputes have arisen involving domain names, and these might be cases where two or more parties have very similar trademarks or the same trademark in a different product or geographic market, which is fine in national trademark law, but it's a problem if there's only one domain name that everyone wants that corresponds to the trademark. You then have disputes involving personal names, and not all personal names, even personal names of famous people, are actually trademarks, so all the trademark-focused law doesn't help with personal name-focused disputes. There's a lot of disputes that involve free speech, that involve the balance between the trademark holder's interest in a domain name and someone who wants to comment on, make fun of, or criticise the trademark holder, and how do you strike that balance in the domain space? Trademark law does have some rules that balance free speech and property rights in marks, but those rules are domestic laws. They're creatures of domestic law and have to be then adapted to the internet, usually under the UDRP. And then there's a bunch of cases that involve other meaningful words and phrases, like cultural and geographic indicators, and religious words and phrases, and political words and phrases. And in fact, even President Obama's last name, Obama.com, there's a city in Japan called Obama that had registered Obama.com, and the people in the city were very big fans of then candidate Obama when he was on the road and gave him the name. But it is just an example of how you can have multiple different legitimate interests in a domain name at the same time. And the issue with the current regulatory system is it really ended in 1999. Nothing much happened after 1999 when the UDRP and the ACPA came into being. And all of those rules are very, very much focused on protecting trademark holders against cyber squatters. So we don't have good practical rules and regulations that deal with all of these other kinds of disputes. And we actually don't really have a very clear theoretical basis on how you would go about doing that if you wanted to go about doing that anyway. We haven't really ever resolved the question as to whether domain names in and of themselves are property, a new form of intellectual property outside of trademark law, whether rights that people have in their personal names are a form of intellectual property. Different states in the US even vary on that, let alone internationally. Whether we should be looking to the law of restitution or unjust enrichment to provide a theoretical basis for someone else making money from a domain name that has some significance for another person or group. So in the forthcoming book that I have, and I don't want to make this an advertisement for the book largely because I don't know when it's coming out or how much it will cost or anything, but feel free to email me if you want to find out, and I'll find out. But I try and explore some of those questions in the book. And I guess it goes back to the question that Dave raised about cyberspace exceptionalism versus unexceptionalism. That is the domain name system something so different to what we've seen before in the real world that we really do need to think about new ways of regulating it and new rules. And one point I would make that I guess works in favour of an exceptionalism argument would be domain names are really one of the very few, and certainly the most prominent, I would argue, non-rivalrous form of online property. because they can only exist in one person's hands at a time. Unlike copyrighted works and ideas and the subject matter of a patented invention, most information can exist in lots of different people's hands at the same time, and copyright and patent are often trying to strike balances between how much monopoly someone should have over that information. Domain names are actually more like real property in the physical world, in that they can only exist in one person's hand at the same time. So like real property, you could license them, or you could try to set up a scheme for joint ownership or shared ownership, but in terms of how the register works, only one person can be registered at the one time for a given domain name. So I wonder whether that's enough impetus to take an exceptionalistic attitude to the regulation of domain names. I know that all of this begs the question whether anyone cares about domain name regulation anymore, because I always get that question, why are you talking about that? That's old news. You know, search engines are so sophisticated that no one cares about domain names anymore. And I don't necessarily agree with that. I think it's true to a point. But if you look at the statistics of domain name disputes, the number of disputes heard under the UDRP increases exponentially every year. If you look at particularly the statistics that WIPO releases, and the WIPO arbitration body hears most of the UDRP disputes. Additionally, a lot of the search engine algorithms, while we don't have access to them, we understand that they do utilise domain names as a significant part of the algorithm. So even if the internet user isn't using the domain name as a search tool, the search engine itself is using the domain name as a search tool. And there are some domain names that I think are probably used as search tools in particular contexts, and I think the political context is a good example. That you know, presidential politics, a lot of people will type Obama.com or McCain.com or Palin.com or whatever it happens to be into a search engine or into a URL bar. So I think certainly with things that have a temporal significance like that, people do tend to use the domain name more as a search tool than they might if they were looking for a trademarked product or service. I have made the case, and I'm not going to talk for very long because we want to be brief and then have room for discussion. I have mentioned my concern that the rules that we have in place, both at the domestic and the international level, are very, very trademark focused. So we have trademark dilution actions, infringement actions. UDRP is all premised on the existence of a trademark, and the Anti-Cyberspotting Consumer Protection Act. There are some examples of laws that do focus on other aspects of domain name regulation, and these are things that might be worth watching in future years as we think about, do we need to take a global and a different and an exceptionalist approach to regulating the domain space. California, for example, has a couple of local statutes, state statutes, that regulate certain things that involve the domain space. One is the Business and Professions Code, which deals specifically with personal name cyberspotting and is much broader than any other law that does that. California also has a Political Cyber Fraud Abatement Act, which talks about making misleading uses of domain names in the political context. So that's a very interesting and quite detailed piece of legislation to look at.